On May 1st, 2025, Reading Police Officer Tanner Vogel and another officer, identified by Ryan Mullis as Officer Sean Heck, responded to a 911 call in Reading, Pennsylvania. Mullis later said the anonymous caller described two Puerto Rican men wearing tank tops and shorts near a blue hatchback, with a woman reportedly tied on the ground. But when officers reached the location, the woman they found was not restrained and did not appear to be in distress. They also encountered Mullis, who said he had pulled off the highway and was working on malfunctioning vehicle lights. What happened next, including the dispute over identification and detention, was recorded by the responding officer's body-worn cameras throughout the encounter.
Brian 310, I'll be with that vehicle. It's a blue Volkswagen. Hey, what's going on, guys?
Oh, I'm fixing my car.
It's gonna be PA Reds, Mike Hotel, Lima, 5054.
Ben, where did you locate it?
Hey. Nothing south.
What's up, man?
It's on South Street.
Fixing my car.
Yeah, just turn it off for a second.
What's going on with it? The lights aren't working right.
Are you guys good?
Yeah.
It's just your car's broken down?
It's not broken down. He's just trying
Or
to fix it.
fix the lights?
Yeah.
Okay. Yeah. Do you have an ID on you?
No, I don't. I'm just sitting in the vehicle.
Is it his car or yours?
It's his car.
It's your car?
Yeah.
Just want to get his ID.
My man, what's your name?
I didn't do it.
What's up?
And we're just waiting for Domino's.
Yeah, I know. That's why I'm asking. Do you have an ID on you?
Did somebody call
You
us
don't?
and shit?
Okay.
Yeah.
They called?
Yeah.
Because of the exhaust emission?
What's that?
No, something else.
What did they call about?
I'll explain it to you. What's your
Well,
name?
we got a call. We'll explain it to you in a second.
It sounds like a giant misunderstanding.
Here, I'll
So,
come out here.
Right now,
Do you have any weapons on you?
You're going to give me your name,
no,
and then we're going to
no.
go from there.
Yeah, no.
And you're not going to give me your name why? Yes, you do. Yes, you do. You're currently detained for an investigation. That's why. Yes.
Here,
you
leave your
need
bag
to
in here,
identify yourself.
I do not have.
You do
Yes,
have to identify
yes, you do.
yourself. He's already on the way.
E-brake
Okay,
is on.
so you can. Okay, call
Hang
me.
tight.
Oh, yeah, we're waiting for pizza, too.
For who?
We're waiting for pizza.
Visa?
Pizza.
Pizza.
Okay, what is the deal here?
The deal is, why did you stop over there?
Because we got a call.
We got a call.
Okay, that's fine. Call all you want, but
And currently, you're under an ordinance violation for working on your vehicle. On
there's
the
no
street.
ordinance
Yes, there
violation.
is.
I'm not working on my vehicle. I'm seeing why my...
Listen, we're going to restart, okay?
Okay, let's restart.
Okay, so you are required under law to identify yourself.
No, I'm not.
Yes, you are.
This is not Germany.
And if you're
This is
not,
the United
if you're not
States.
going to identify yourself,
Frozen.
you're going to be detained in handcuffs.
Detained in handcuffs is different.
So do you want to give your name or no?
But listen to me.
No. There's no conversation. You're either going to identify yourself.
First
or
of
you're
all, you can't detain.
Okay. Put your hands
Hold
on your
on.
back.
I will show you my ID. I'll show you my ID right now.
We'll get it.
I'll show you my ID right now.
Stop.
Go.
I will show you my ID.
We're past that.
We'll pass.
Oh, okay. Well, the funny thing is, you guys are fucking up because you didn't wait for your you didn't wait for your
where's your
supervisor to get here.
No, we
don't
You
need
didn't-
to.
It's right here.
We don't need
You
to.
didn't wait for your supervisor
Don't
to
need
get here.
to.
Yes, you do. Yes, you do have to wait for
You
your
might
supervisor.
want to learn the law a little bit better.
I know the law. We don't live in Germany. We live in the United States of America, where you do not have to ID if you're not suspected of committing a crime.
Wrong.
Well, not wrong. You guys are wrong.
You're wrong.
You're committing an ordinance violation.
There's
right
no
now.
ordinance violation.
You watch
It
a couple
doesn't.
TikToks doesn't mean you're
There's no
right.
TikToks. It's called you. You can. You guys are wrong. You're wrong, and you'll be sued. Then I'll sue you.
Go ahead.
I will, because you're wrong.
Okay.
Okay. I do not have to ID unless I'm being suspected of committing a crime. You have to reasonably articulate. You have to legally articulate a crime. That's what you have to do. No, you have to
any
legal.
weapons on
No,
you?
don't pat me down. I do not submit. No, I'm not. You cannot fucking. No, you are not allowed to touch me in my pockets.
He's gonna cut him loose.
You have to legally articulate a crime. Stop touching me.
Do you have any?
Stop touching me. Stop touching
He has
me.
a
Yes,
gun.
I do have a weapon.
He has a gun.
But stop touching me. I do not. No, it doesn't matter. I do not have to articulate. No, it doesn't matter. It doesn't matter if I have a gun.
by.
I'm allowed to have a gun.
Do you have a CCW?
No, I didn't. I'm not going to show you. I'm remaining silent. I have the right to remain silent.
You're correct. Now you do have
No,
the
I
right to
had the right to remain
so
silent, and
that'd
you had no
probably be
right to
best.
touch me. You had no right to touch me. You're done. You are done. Not me. I'm not IDing either. Do not take my ID. You are not. I'm not IDing. There's nothing in it.
I have to make sure.
It doesn't even fire.
Okay, then why the hell would you carry it?
Because it's called ready.
Right, 332. 332. One detained. We have a firearm. One detained with firearm. 2205.
The officers then place Mr. Mullis in handcuffs, perform a pat-down, and locate a firearm concealed on his person. While the legality of the detention itself will be examined later in this episode, discovering the firearm brings two Pennsylvania statutes into play. Section 6105 of Title 18 of the Pennsylvania Consolidated Statutes prohibits individuals convicted of specifically enumerated offenses, along with people falling within other prohibited categories such as fugitives from justice, from possessing firearms in the Commonwealth. Section 6106 of Title 18 separately restricts carrying a firearm inside a vehicle or concealed on the person outside one's home or fixed place of business without a valid license to carry. At this stage, however, a potential Section 6105 violation would depend on Mr. Mullis's qualifying criminal history, while a potential Section 6106 violation would depend on his licensing status and any applicable exception. Because those facts cannot be established from this portion of the body camera footage alone, the footage itself is insufficient to determine whether either statute was violated.
No, I'm not working on it with it. I'm still on my record.
Writing 304. 304? Transport to what I call female from this location down the central processor. Starting mileage 44376.4.
Yeah, please record the
Honey, drop it.
room.
Scope 310.
Stand by. 305 on fill. Good. Negative on the way. He has a combination with motorcycle and a Class C, I'm guessing. Address on that is 122 Kramer Road in Millis. Copy. Can you check in for a CCW, please? 10-4. Go ahead, 10.
Alright, can you run a firearm for me?
10.
Alright, it's gonna be a Stoger. I believe 9mm in check. But, serial number is going to be Tango 6429 06 Alpha 003280.
You're a public service then, right? Are you not a public service?
Ready, scope.
What's that? Yeah.
It doesn't matter. No, I have a lot of money and I'm going to sue you in court. Yes, okay.
Perfect. Then
You're the supervisor and you're a ringleader of the circus.
So we're going to stop talking.
Correct.
Then. So we're going to
No, we're not going to stop talking because I'm asking you a question.
Well, I'm not talking.
I'm asking you a question. These men came up on me with guns, and I'm asking them why they need me to ID when I'm not committing a crime. They need a crime
Well, when you
to
stop
get
talking,
ID.
maybe we can answer questions.
Okay, answer those questions then, please.
Oh, we're
Answer
not
those questions. Before he took my side piece, you know what he did? He told me I was under arrest for not IDing. Do you know what that means?
Yeah, you have to ID yourself.
No, I do not have to ID myself.
One of the officers advises Mr. Mullis that he is legally required to identify himself, while Mr. Mullis maintains that no such obligation exists. In the 2004 Supreme Court case, Hebel versus 6th Judicial District Court of Nevada, the court ruled that a state can require a lawfully detained person to provide their name during an investigative stop, but only when state law specifically creates that requirement. Neither Pennsylvania nor the city of Reading has enacted a stop and identify law generally requiring a person to disclose their identity merely because they have been detained during a Terry stop. That means refusing to provide identification during a detention is not, by itself, a criminal offense or an independent justification for arrest. And even if Pennsylvania had such a requirement, the Supreme Court's 1979 decision in Brown versus Texas establishes another important limitation. A stop and identify law cannot be used to compel identification when the detention itself lacks reasonable suspicion based on specific articulable facts suggesting that criminal activity is occurring. That reasonable suspicion requirement comes from the Supreme Court's 1968 decision in Terry versus Ohio and represents the constitutional threshold officers generally must satisfy before conducting an investigative detention. In this encounter, there is a substantial argument that neither the information contained in the 911 call nor the ordinance violation referenced by officers supplied sufficient reasonable suspicion to justify detaining Mr. Mullis. The Supreme Court addressed anonymous emergency calls in the 2014 case Navarrete versus California, holding that a 911 report may establish reasonable suspicion when the tip contains sufficient indicators or indicia of reliability. The court explained that a caller describing events personally witnessed can demonstrate first-hand knowledge which can significantly strengthen the reliability of the information being reported. Here, however, the caller reportedly claimed to describe events personally observed, yet important portions of that description were not confirmed when police arrived. Officers located a blue hatchback, but they did not find a woman tied up on the ground. The woman who was present did not appear to be in distress, and instead of encountering two Puerto Rican men wearing tank tops and shorts, officers encountered Mr. Mullis, a white man dressed in a t-shirt and jeans. Because significant details from the reported scene were contradicted rather than confirmed, and because officers encountered no apparent evidence of the reported criminal activity, a court could potentially conclude that the 911 tip lacked sufficient reliability to support Mr. Mullis's detention. The officers also referenced Section 576-405 of the City of Reading Code of Ordinances. That provision prohibits a vehicle from standing on a street or sidewalk for greasing or repair work, while specifically providing an exception for emergency repairs. Officers apparently observed Mr. Mullis performing work on his vehicle, but Mr. Mullis explained that malfunctioning lights had caused him to leave the highway and that he was attempting to repair the problem. If those circumstances qualified as an emergency repair under the ordinance, a court could potentially determine that the officers lacked reasonable suspicion of an ordinance violation on that basis as well. Accordingly, there is a substantial argument that under these circumstances, Mr. Mullis could not be compelled to identify himself merely because officers detained him, and that the underlying detention itself may have lacked the reasonable suspicion of criminal activity required by the Fourth Amendment.
You know, by
Not unless I'm arrested.
Listen, by Pennsylvania law, you're required to carry your license with you.
Let me get my phone. No,
So
get
by
my phone.
Pennsylvania law,
I'm allowed. I have to record. Yeah.
So what,
I
you
have
don't
to
do you
bring
have
my
the
ID at all
Do you
times.
have it on you?
But you can't legally
I have
request
an ID.
it. You can't legally request it. Where's my phone? I will show you the law right now.
You know what?
And you go ahead. Do your thing.
If you weren't, if you were nice and you weren't being an
I don't
ass,
need to be nice.
we would have
I
been
don't
out
need
of
to be
here.
nice. Don't matter.
10.
Negative stolen, but it does come back to an Andy Earl Mullis Jr., date of birth 9/27 of 52.
Copy. Okay.
Stuck in the committee to detainment.
His dad's. Okay.
050 on scope. I'm still looking to see if that they don't have CCW. I'm just running out of
Articulate that I was committing in order to detain me. In order, you understand that? And they're detaining me for no reason. No articulation of a crime.
We do have one.
Which one? Which one is that?
You even said it. We don't have to tell
Exactly.
you. So
Yeah.
exactly.
You didn't know that.
So,
Yeah, you didn't know that. Yeah, but it doesn't matter.
Deal.
I'd love to see what crime I'm committing.
Okay.
I would love to
We'll
see
find
that.
out.
Yeah, okay. We'll find out.
Like I said, we're
we
done
definitely
talking.
will find out. And then
We're
we're
done
gonna be suing you.
Okay.
All right, cool. That's great. I'm glad we're gonna suing you. Unless you guys want to walk away right now, or I'm gonna sue you. I'm being serious. I'm being real serious.
I said we're done talking.
You better call your DA if you don't have somebody on top of you. You better.
I don't have anyone on top of me.
You better then call your DA and tell them that this is what you did, because if not, I'm gonna sue. I'm being serious. You're wrong. I'm right and you're wrong.
Okay.
You
didn't see the amendment violations and shit like that? You didn't watch YouTube? Tell you about
What was
it?
violated? There you
Tell
go.
you about it?
That's where you got your law
What's
degree.
violated? My Fourth Amendment, for one, is violated.
Okay. What else?
I don't need to give you my papers.
Just like we don't.
Anytime. No, you're a public servant. You can do whatever. You can do what you want, but you're a public servant. I'm not. I'm a citizen. I pay
I'm a
taxes.
citizen too. Me too.
Yeah, but you're still on duty.
Okay.
Are you not?
On our bed.
Yeah.
Yeah.
Thank you
but
for
are you
paying
not?
us to detain
all right.
you.
All right. So,
All right.
what's your badge? 13113.
Yep.
Yep.
Sam!
It'll be in the paperwork.
I don't care about the paperwork. Can you give me my cell
How do
phone?
you plan on taking this to court?
We are taking this to court because you
clearly
can't.
said
You
didn't care
cannot
about the paperwork.
You cannot.
How you gonna do that then?
You cannot detain somebody for no legal crime. You can laugh all you want.
We have one.
What is it? What's the crime?
Like I said, we don't have to tell you.
Yes, you do. When you arrest somebody, you do.
Right?
And I'm arrested. So what are you detaining? Yeah.
No, we just told you.
Yeah. What is it?
We don't have to tell you. You said that.
I didn't say that.
Yes, you did.
I told you can't
play it
arrest
back on the
somebody
body cam
and
right
search
now.
somebody. No, you can't.
We didn't search you.
Yeah, you did. He did. He patted me down and he took my ID.
It's not a search.
Yes, it's not a Terry search. I can tell you that.
It's not a search.
It's not a Terry stop. No, it's not a Terry. Yeah, but even if it was, you still have to reasonably articulate a crime.
Mr. Mullis repeatedly asked the officers to identify the crime they believe he committed, but the officers declined to provide him with an explanation. Under the Terry standard discussed earlier, reasonable suspicion must be articulable. In other words, officers must be capable of identifying the particular facts that supported the detention if their actions are later examined in court. But that requirement does not mean officers must articulate those facts directly to the detained person while the encounter is unfolding. The Constitution generally does not require police to explain the justification for an investigative detention at the scene. A similar principle applies to an arrest. In the Supreme Court's 2004 decision in Devenpeck v. Ulford, the court explained that although informing someone of the reason for an arrest may represent sound police practice, the Fourth Amendment does not make that explanation a constitutional requirement. Instead, the legality of a warrantless arrest turns on whether the objective facts known to the officer establish probable cause for an offense, rather than which particular offense the officer states or chooses not to state during the encounter. So while the officer's refusal to explain their reasoning to Mr. Mullis was not, standing alone, unconstitutional, that refusal could not rescue an arrest that otherwise lacked probable cause. Probable cause is evaluated according to the facts and circumstances known to police, not according to the explanation officers provide or refuse to provide to the person being detained. In practical terms, this creates an important limitation for anyone involved in a roadside encounter. A person may not be able to accurately determine in real time whether a detention or arrest is legally justified, because that determination can depend on information possessed by the officers that they generally are not constitutionally required to disclose on the scene.
I'm losing brain cells. God damn. Yeah, it's rubbing off from you.
305 on Silver.
You're being serious. I can take you serious in a request. I'll believe that.
You told us many times we're not stupid. We understand. So you can stop talking now.
Firearm that can have you run. It comes down to possibly a family member, but not him.
Yeah, well, it's not. It doesn't matter.
I'm tracking.
Thank you.
Stand up.
Stand up.
Okay.
Stand up.
I'm trying to stand up.
There you go. Come over here.
Okay.
Well, what was your probable cause anyway to detain me? Because you need probable cause to detain somebody.
Do you just want me to call the wagon?
Yeah, please call the wagon, because you know
I'm not
what?
talking to you.
I don't give a fuck who you're talking to, because you're a public servant, and I'm a citizen that pays your... I pay your paycheck, you understand that, right?
I pay my own paycheck.
No, you don't.
Yeah,
I do.
I pay
Who pays you?
I pay taxes.
Yeah, but you pay enough for $101,000 a year? Is that what you pay for?
No.
You make that's what you make a year. $100 some thousand dollars a year.
You know how much I made last
year.
year.
Yeah, I do exactly know how you make.
Alright, have a seat in the car with me.
I'm glad that
Step in and watch your head.
you guys understand that. If you guys allow her to take my car, then guess what's gonna happen? I'm trying to.
Let me guess. You're gonna sue us.
I'm already gonna sue you. Because you got no problem calling.
What's up?
Did you have anything in his pockets while we're in?
Just his wallet. I didn't go through his wallet. Just double
He
check
did have
that.
keys in his. He's an idiot.
For Bacon and Street.
Yeah.
Don't call me.
I know. Like literally.
This would have been gone.
People just don't
In 2
understand
seconds.
that all you gotta do is just
Their car was broken
answer
down.
simple
And I was just
questions.
going to write their names down.
See ya.
Bada bing, see ya. And now, motherfucker's getting arrested for a gun. Idiot. Scope 310. What's that guy's name again? Andy?
I can't go back and remember.
Ryan Mullis or something? It's in the returns.
Yeah.
I have it here. Whose ID someone with me?
Scope 310. Hey, could you also start a triple I on this Ryan Mullis?
Other ID.
Writing police dispatch.
It's his car, right?
I didn't even check.
Because, do you have a license, dear?
Yeah, I just don't have my
Well,
ID on
because
me.
here's the problem. He doesn't want you driving his car.
Oh, that's fine. That's fine. Does he want mom to come pick it up, or does
I don't know.
are they gonna tow it?
That's not a tow truck.
Yeah, that's not alright.
Oh,
That's not ours.
oh,
I think it's just ran it by.
Good luck.
that's crazy. I know the guy.
Change it to the third vehicle, clear it out paper.
How do you know him?
The tow guy?
No, this
No,
guy.
this guy.
Oh, that's my ex-husband.
What's that?
That's my ex-husband.
Ex-husband?
Yeah.
Okay.
Where's he at?
He's in your car.
He's in, oh, alright.
I would go down there.
Alright, cool.
Hey, well, do you need to talk to him still?
Yeah, we have a. Sorry. Well, let him finish up.
Yeah.
We have a fire extinguisher we gotta give you, but we'll chance for him to come and find you. Okay. Alright, cool. I had a look.
Yeah, thank you. Charge is going to be carrying without a license.
Alright, cool.
Yeah, that's the main one.
Even though it's grandfathered, it's literally.
There's no license to carry.
What's is this yours then?
Huh? I guess so. It is mine.
Alright.
What are you gonna do in the car?
I mean,
It's up to you.
I don't really give a fuck if it's parked back here, but...
Yeah, like she lives like right into the woods. I don't know if he calmed down at all.
No.
It is what it is. Yeah, just secure it and then just keep going.
Alright.
Unless you have a reason to tow it or wanted to. Yeah. There's a bunch of cars parked here. So
Yeah, I...
Bunch of booze.
Yeah. No, that explains him as well. So...
we checked the trunk. There's nothing back there except random stuff.
Alright. I'm just making sure there's nothing crazy in plain view. So. You see anything?
Well, I'd be able to grab my bag then.
Oh, which one's yours? The black one?
Yeah. Alright, there's.
Just trying to see if I can find it.
I don't think there's anything in there. That's
Okay.
207.
Alrighty. Well,
except maybe a salt
I'm clear from noise.
See through
Must
though.
be at the
I'm not worried about it.
South 7th, the canal.
It's funny too, right?
Well,
Do
let's...
you need that?
No.
Ready, scope.
10. He'll be at central processing.
So, I mean, later you're gonna have to come up to get that triple I, but he does have previous charges on his record that he pled guilty to.
Okay, I'll come look at it then. She's good, girl.
2221.
What's going for?
Carrying without a license, and apparently he has criminal history.
Oh, really?
So it might be more.
Well, at least that charge.
At least, yeah, carrying without a license.
Okay.
He just had an empty firearm on him.
Mr. Mullis was ultimately arrested and charged with unlawful possession of a firearm, graded as a first-degree felony, carrying a firearm without a license, a third-degree felony, and violating Reading's ordinance governing greasing and repair work on public streets. Bail was set at $50,000 and he was released on May 16, 2025, after securing bail through a professional surety. On February 19, 2026, the Berks County Court of Common Pleas granted a defense motion to suppress evidence. Then on May the 29th, 2026, the court dismissed the charges and discharged Mr. Mullis. On July 8th, Mullis filed a motion seeking the return of his property. That motion remains pending, with a hearing scheduled for August 20th, 2026. According to Mr. Mullis, the encounter resulted in 15 days in jail, approximately $5,000 paid to obtain his release, and roughly $15,000 in criminal defense expenses. As of the preparation of this episode, Mullis has also stated that he is attempting to obtain legal representation for a potential civil rights lawsuit. Overall, the reading officers receive an F for detaining and arresting Mr. Mullis after his refusal to identify himself, despite the absence of a general Pennsylvania law requiring identification under these circumstances, repeatedly presenting disputed legal claims as settled law, and maintaining an unnecessarily antagonistic and dismissive attitude throughout much of the encounter. The officers unquestionably had authority to respond to the 911 report and investigate the circumstances they encountered. But once they arrived and found no woman restrained on the ground and no individuals matching significant portions of the caller's reported description, the factual justification supporting continued detention became considerably weaker. Instead of reassessing those circumstances, officers demanded identification under the threat of handcuffing Mullis, insisted that the law required him to identify himself, and interpreted his refusal as non-compliance rather than addressing the underlying legal issue. An investigative detention must be supported by articulable, reasonable suspicion of criminal activity. In a jurisdiction without a general stop and identify requirement, refusing to provide a name cannot independently manufacture the suspicion necessary to justify that detention. The ordinance referenced by the officers presents another problem. They were aware that Mullis claimed he was attempting to repair a disabled vehicle after experiencing malfunctioning lights. Because Reading's ordinance contains an exception for emergency repairs, reliance on that provision as the basis for continued detention was legally vulnerable under the circumstances presented here. The officers' conduct after Mullis was detained also deserves scrutiny. Their body cameras captured dismissive and disparaging remarks about him, along with an officer explaining that the original encounter was expected to involve little more than obtaining the individuals' names before everyone went on their way. That statement is significant when considered alongside the later suppression ruling and dismissal of every charge. The suppression ruling provides especially important context because it indicates that the defense successfully challenged evidence in the criminal proceeding. Still, the precise reasoning should be attributed to the court's suppression order rather than inferred beyond what the available record establishes. The broader lesson is how quickly an investigation originating with a questionable tip and a relatively minor ordinance issue can develop into serious felony charges when disagreement over constitutional authority becomes part of the encounter itself. Mr. Mullis, meanwhile, receives a B for correctly recognizing the central identification issue and continuing to assert that position without physically resisting the officers, while also misunderstanding several important legal standards and continuing to volunteer information after stating that he intended to remain silent. Mullis correctly challenged the proposition that detention alone automatically created a duty to identify himself. He maintained that position even as officers escalated from verbal commands to handcuffing and arrest. He later challenged the government's evidence through counsel, obtained a suppression ruling, and ultimately saw the criminal charges against him dismissed. However, Mullis also repeatedly confused reasonable suspicion with probable cause. Police do not generally need probable cause merely to conduct a temporary investigative detention. Under Terry v. Ohio, reasonable suspicion can be sufficient when it is supported by specific and articulable facts. Officers also are not constitutionally required in every circumstance to explain their complete factual basis for a detention or arrest while standing on the roadside. Whether the seizure is lawful depends principally on the information available to police, not merely on what the detained individual knows about that information at the time. That distinction matters here because Mullis could not have known everything communicated through the 911 call or police dispatch. Although the reported information in this encounter may have been insufficient once officers confronted materially different circumstances at the scene, another call containing sufficiently reliable and corroborated information could potentially support the same type of investigative detention Mullis was challenging. There was another practical mistake. After announcing that he was exercising his right to remain silent, Mullis continued speaking and volunteered information concerning the firearm and the circumstances surrounding his possession of it. Invoking the right to remain silent offers little practical protection when a person immediately continues providing potentially relevant information voluntarily. Those statements potentially gave investigators information they otherwise might not have obtained directly from him. Even so, Mullis deserves credit for asserting what he believed were his constitutional rights under significant pressure, avoiding physical escalation beyond verbal protest, and ultimately taking the dispute into court rather than attempting to resolve it physically on the street. The subsequent proceedings produced the result that matters most for the criminal case. The defense obtained suppression of evidence, and the charges against Mr. Mullis were ultimately dismissed. If there is another police encounter or constitutional issue you would like examined in a future episode, leave it in the comments below. Thanks for watching, and subscribe for more detailed breakdowns of the constitutional and legal questions behind body camera encounters.